to the extent that the transcript has referred to the names of the children, it should be amended. The transcript should be amended simply to refer to their initials, L, P, R, T, N, T. And I don't believe there's any objection to that from either side. Is that correct?
No objection.
Okay.
No objections.
All right. And I believe before we proceed with closing, you wish to renew your motion?
We do, Your Honor. We wish to renew our motion for a directed verdict pursuant to MCR 2.516, 9.210, and 9.211.
Right.
I don't, without belaboring the matter, as I indicated before, even in taking the evidence in the light most favorable to the examiner and the co-examiner, they have not established what they've alleged in their formal complaint. They have not established a violation of 9.205. They have not established any violation of the canons of the Code of Judicial Conduct. And for those reasons, Your Honor, the court should grant our motion for a directed verdict.
All right, I understand that. And any response on behalf
Well,
of
my response would be pretty much similar to what I responded with before as far as the dispositive motion issue is concerned. Furthermore, the tape in conjunction with the exhibit that was admitted, number 69, certainly there is more than ample evidence on all aspects of the formal complaint, on the misrepresentations as well as the treatment of the children, as well as the violations of law and not following the law of contempt and the way that that aspect was handled. So no, I would object to that.
Right. Under 9.210B2, the motion will be denied at this time, but will be addressed in my findings of fact and conclusions of law. Right, subsequent to the conclusion of the hearing. Are you ready to proceed with your closing?
Yes, Your Honor.
All right, you may proceed.
Judge, in the opening statement, counsel for respondent stated that perhaps the only thing that respondent is guilty of is caring too much. This is not a case about caring too much. This is a case about following the law, and this is a case about due process rights and the due process rights of the children that were involved in a divorce. Any judge sitting on the bench has an incredible power. It's the power that goes with the bench, and that power cannot and should not be allowed to be abused. When you're sitting on the bench, you can't violate anyone's due process rights. And in this case, the due process rights of those 3 kids was clearly violated. Those kids were locked up for 17 days. And to simply say, well, appeal me, it doesn't change the situation that these 3, a 9, a 10, and a 13-year-old child, were locked up on what was clearly a criminal contempt without a petition, without an affidavit, without a hearing. Now, the one thing that we can, I think, all agree is that obviously this was stemming from a divorce and post-divorce motions that dealt with parenting time issues and problems. I don't think anyone will dispute the fact that there were issues and problems. But more than anything else that comes through all those issues is the fact that the mother had allegedly alienated those children from their father. This record and all the exhibits presented to you clearly indicate that the allegations were the mother had done that. In fact, the guardian ad litem said at the July 10th hearing, God bless you, mother, because you tried hard and you've succeeded. And the mental damage that was done to those children. And the mother had been before the court, before respondents so many times, and was warned. Again, as Mr. Lance had testified, stop it, stop it. and yet nothing was done to the mother. Oh, on April 2nd, 2015, she agreed to do 1 day in a lockup behind the courtroom, and that was cut to half a day because, God forbid, she should be strip searched. Respondent had given the mother all the due process rights. Mr. Lancet testified that there are constitutional rights for these children to parenting time. I'm actually not certain what he was talking about, but there are constitutional rights that these children have in not being held in an illegal contempt hearing, which was done on June 24th. And if you recall this morning's videotape, Lancet said, "You can't move their mouths. You can't tell them how to feel." But that is precisely what respondent was doing, ordering those kids to love, ordering those kids how to feel. And you cannot forget one thing. That divorce was filed in 2009. These kids, at least the youngest one, was barely beyond toddler years. There's testimony and evidence that talks about the kids calling 911 during visits in 2010. In 2010, that little girl was not yet 4. Her brother was 5, depending on which month you're talking about, perhaps 6. These children were calling 911. We all know that civil contempt is essentially as one witness testified. You as a judge order a witness to answer a question. I think the example that was used was a reporter. And when that person refuses to respond, they hold the key in their hands. They're locked up, brought back an hour later, maybe a day later. But they are brought back to inquire, have you changed your mind? This was not civil contempt. Even Judge Gorcyca's testimony shows that she just about had it, and she was going to punish those children. And perhaps the best evidence of that are her own words. In paragraph 25, and again in paragraph 61 of her 28-day letter answer, she states, quote, on June 24th, 2015, the children were found to be in direct civil contempt of the court for failing to comply with the parenting time order of this court dated June 23rd, as well as for repeatedly failing to respect and obey the previous parenting time orders of the court, despite the court's warnings and admonitions that confinement to Children's Village would result. Another proof that this was a criminal contempt, 3 attorneys who were appointed to this case. If you look at the videotape of June 24th, 2015, they each set out on a record that they advised their clients to apologize for not following the court's orders. Next piece of evidence, the sentence. For For 17 days, those children were locked up. Review, September 8th, 2015. Bypassing the fact that Judge Gorcyca told each and every one of those children that they will not have a review until they were 18, unless their father decided and determined when they were, quote, normal human beings. I believe on my direct examination of Judge Gorcyca, she testified that it was very clear that the key to their freedom was in their hands. The only person who had that key, Judge, was the father. Repeatedly throughout the tape of the June 24th, 2015 hearing, Judge Gorcyca says, I will review this when your father tells me to review it. I will review it when your father tells me that you're normal human beings. The day before, Judge Gorcyca was advised by the dad's attorney, my client is going to be out of town for over 2 weeks. And lo and behold, on July 10th, 2015, during that hearing, the connection with Mr. Simoni was made via telephone, and he clearly indicated, I am in Israel. He was the only person who held the key to those children's freedom. For 17 days, during which Judge Gorcyca also deprived those kids of any contact with each other and with their mother. And we are talking about a 9, a 10, and a 13-year-old. Even if the argument is, well, there was a violation of the June 23rd order, that's still a prior order. There's even case law that states that if you as a judge defer a contempt issue to the end of a trial, it becomes criminal and requires the filing of a petition and an affidavit. But beyond that, let's look at that order. The order is talking about the 9-year-old and 10-year-old. Parenting time in a court's jury room the following day, June 24th. And they came. And again, as Mr. Lancet said, you can't move their mouths. You can't tell them to love. You can't force them to love. But Judge Gorcyca decided she was going to, just like she took away their electronics and said no food at mom's house. Those are all orders. LT was not covered by the June 23rd order. That child had absolutely no obligations to be there. And that's yet another proof that the intent behind the hearing on June 24th was clearly a criminal contempt hearing, because by George, Judge Gorcyca was not going to allow these kids not to completely and totally obey her as to how to behave and how to love and how to talk to their father. Civil contempt is supposed to be coercive. It's supposed to change the attitude, actions. Do what the judge ordered you to do. Answer a question in court, on the record. And keep in mind that there was nothing on a record prior to the attorney's appointment on a contempt hearing. 17 days later, inasmuch as Judge Gorcyca had Ms. Kelso come over and testify today that things have improved, they haven't. Those children have not changed their minds. And yet she did dismiss that contempt. And bypassing in addition to the fact that this was a criminal contempt held illegally in violation of these kids' civil rights, due process rights, then there's the hearing itself. From the bench, the judge, with all the power behind her, raises her voice, is sarcastic, is demeaning, laughs at them, tells them they will be in jail. How is that not punishment? How is that not trying to terrorize a 9, a 10, and a 13-year-old? And inasmuch as Deputy Maloney stated that, no, I didn't see the 9-year-old crying or sobbing as I was taking her out, the tape speaks for itself. I don't know where that man was, because we all heard and saw that child. The comparison to Charles Manson. Charles Manson reference was used by Mr. Lancet. Inappropriate completely. It begs a question as to why he would even think of resorting to that. But bypassing that, that was for the eyes of the court. Maybe the attorneys. But to throw that in the face of a 9, a 10, and a 13-year-old? In effect, do the research on the man and his cult who have murdered 7, 8, 9 people, one of them a pregnant woman. We expect the judges are going to be courteous and respectful to all those who come before them. And children deserve no less. During the same hearing, Judge Gorcyca also made clear to tell those kids, I like your dad. I wouldn't even tell you what I think of your mother. The JOD prohibits that specifically. You will not badmouth or disparage the other party. And yet she gets to do it from the bench. Oh, and her explanation is, no, I never had any conversations with Dad. I just said that because I wanted the children not to think that the father had asked for their incarceration. Really? So now you're lying to the kids from the bench? In effect, Judge, her anger boiled over. When the 2 younger ones apologized to her during that hearing, that wasn't enough. And the only thing she claims she regrets today was advising the middle child that his older brother is already in jail, even after the 10-year-old said he would try, addressed his father. And the 9-year-old sobbing said, I will try to work with my dad at visits. Judge Gorcyca didn't see that as enough. No, she had to terrorize them a little bit more. Well, you're going to stay here all afternoon. And if you have any hesitation about having lunch with your dad, I'm going to have the deputies come at 1:30 and lock you up, take you to Children's Village. And then there is the circular motion that Judge Gorcyca had made at her temple, which now she claims, I don't remember it. You're a judge. You're on the bench. You don't remember what you do on the bench? And perhaps that statement is an indication of how totally and completely out of control she was. Did she not remember? Well, let's look at some of her other motions. At one point in time, she looks at the oldest child, the 13-year-old, for the record, puts her fingers together, points to her temple and says, "You are so mentally messed up. And while she makes the circular motion, what is she talking about? She's telling Dad, when you think your son is no longer like Charles Manson and his cult, clearly referring to someone being mentally messed up, crazy. There are some gestures, Judge, that are universal. If I extend my index finger at you and keep bending it towards me, I can pretty much predict that you're going to start walking up to me. And I'm certainly not being flippant, but if I raise my middle finger, you will be insulted. If I make the motion that Judge Gorcyca had made, clearly that is what she intended to convey as a message to this 13-year-old. To say, I don't remember, well, that's also contradictory to what she said in her 28-day letter, that she intended it to mean as the wheels of therapy moving forward. How credible is that? The wheels of therapy. When I'm talking about Charles Manson and his cult.
Your Honor, I've let this go on a little bit, but she's completely misstating the evidence in this case.
You'll have an opportunity to respond.
As she's talking about Charles Manson and his cult and making that motion, that's supposed to refer to the wheels of therapy. Not likely. You can't dictate love. Love is earned. As respect, which is also earned, cannot be forced. Judge Gorcyca stepped out of line. She violated the laws. She, in fact, in this July 10th hearing stated, I removed the children. Yeah. In violation of the statute that states you cannot remove a child in a custody proceeding without a hearing. On July 10th, she also said, I place these children in a situation where they could get counseling outside of the influence of both parents. How is that not an absolute misrepresentation? Because the only parent who had any right to have access to these kids was the father and anyone that he approves. And chances of his approving the mother are zero. And during the July 10th hearing, Judge Gorcyca, blamed everybody, including the media, for misreporting what she said from the bench. You will be in jail cells. You will live in Children's Village until you are 18 or graduate from high school. Your father is loved by the community, by his colleagues, and then had to admit it. She never had any contact with anyone. Like I said before, Judge, you can't use the bench to scare. You can't use the bench to terrorize. You can't use the bench and the power of contempt, one of the greatest powers that a judge has, in an illegal manner. And once again, let's not forget, these kids started in this divorce proceeding as toddlers, at least the youngest one. That's all they've ever known. On top of that, the judge locked them up. Clearly, there is proof on every paragraph of the formal complaint. Thank you.
Closing for respondent.
Your Honor, I can't tell if I was at the same hearing that Ms. Renier was at. I don't know where any of this evidence that this was a criminal contempt hearing comes from. The fact of the matter is, Your Honor, Judge Gorcyca testified from that stand that this was a civil contempt hearing. The attorneys for the children, notwithstanding their statements on the record or their statement that they asked their clients to apologize, all acknowledged to this court that this was a civil contempt hearing. They knew when they were appointed that this was a civil contempt hearing. When you look at the hearing, Your Honor, it is clearly a civil contempt hearing. The judge brings the people in front of them and says, "Are you going to follow my orders?" And they say, "No, I am not going to follow your orders." And the judge says, "Can you please follow my orders?" And they say no. Now, Ms. Renier makes a big point of saying, well, these were prior orders, and so obviously this was a punishment situation. The problem with that, Your Honor, is that every order is a prior order. Until this court speaks with an order, there is no order to violate. The kids were told to participate in parenting time the day before, the month before, 3 months before, 9 months before, 5 years before, and it never worked. And so the court, having tried a number of different things in order to get these children to try to have a relationship with their father, to try to get them to communicate with their father, the judge knows that she can't legislate love and respect. The judge knows that she can't make these children like their father. But the judge also knows that the father has a right to parenting time. The judge also knows, as Mr. Lansat told us, that the children have a right to parenting time. It's the time that she can order. It's communication. She knows if a child goes in to a parenting time session and crosses their arms and defiantly ignores the father, refuses to talk to the parenting time supervisor, refuses to talk to the father, refuses to talk in any meaningful way with the family counselor of the court, refuses to talk to the judge, that there's never going to be a relationship even started, built. So what she said was, listen, Get in there and talk to your father. Get in there and participate with parenting time. Get in there and communicate. And they all said no. They all said no in the view and presence of the court. And the court, appropriately and well within her discretion, said, until you follow my orders, and she says it very clearly, I am putting you in Mandy's place until you follow my orders. A court speaks through its orders. The keys to their freedom were, I suppose, using the words of Ms. Rainier, given to the father. But they're never given directly to the father. The father visited Mandy's place 2 days later. Mr. Lancet visited Mandy's place every week while they were there. Each time, Mr. Lancet asked them, what do you want? You want to make some changes? Liam seemed to be coming along, he said in the hearing. Everybody knows that if these children make the choice, they'll be brought immediately before the court within a day or so, when they can tell the court, I've purged my contempt. I've decided I'm going to participate in parenting time. Please let me go. And the judge would do so, because that was the nature of the contempt. She did not say, I am sending you to Mandy's place for a definite sentence because you didn't have lunch with your father. She did not say, I am sending you there because you turned your backs on your dad. I am not sending you there because you locked your arms together in the hallway and refused to move when 6 deputies told you to, when the GAL told you to, when the assistant prosecutor told you to, and when the family counselor told you to. She said, Judge Gorcyca from the bench said, I am sending you to Mandy's place because you have told me you will not participate in parenting time. Your Honor, I know that you are very well versed in areas of contempt. It is true that it was prior orders that brought the children before the court, because quite frankly, if there wasn't a prior order, these kids would have never gone near anybody. These kids and their mother would have stayed behind. There were a series of orders, Your Honor, 30 orders, I think it was testified, bringing these kids before their father for some meaningful parenting time. None of them were followed. That's true. That's true. But the judge never punished the kids for that. The judge did try some lesser sanctions. The judge said, bring the kids to my jury room for parenting time. When that didn't happen, that was not because they didn't participate in parenting time before. That was, as the judge said, with the hope it's going to work and I'll be there to intervene if I can. That was a prospective order. Come to my jury room and we'll get this done. It didn't work. The children didn't improve. A couple of months later, the judge says, if you don't participate in parenting time, the children lose electronics, TV, visits with friends. If you don't eat when you're with your father, the children do not get replacement meals. Those are prospective orders, Your Honor. We're not saying you lose all your electronics because you weren't there yesterday. We're saying you lose electronics until you participate. The judge said, you will come to my jury room or to my courtroom every day during spring break so that your father can participate in parenting time. That didn't help. Your Honor, the judge had tried everything she could. All of these lesser restrictions, all of these lesser conditions, before she finally had nothing left in her toolbox but to say, I can't get through to you kids. I'm a court. I have a series of orders, over 55 pages of this register, over in these 3.5 feet of stacked documents. I have orders that have told you to participate in parenting time. I can't get through to you. Are you going to do it? No, I'm not going to do it. LT says, I will not talk to him. RT says, I will go with my brother. Where? Children's Village. NT says, I'm not refusing because my brother's refusing. I refuse because I want to refuse. We are not going to go have lunch with our dad. We are not going to talk to him. We are not going to do anything. We prefer to go to Children's Village. Judge, what can she do under those circumstances? Here's what you have. You have somebody coming before you in a court of law and say, no, you have no power over me. You have no right to tell me what to do. I don't know what's working in the background, Your Honor. I don't know that this is all the mother, that this is parental alienation. I don't know that there was ever a hearing that determined that. I think somebody told these kids, you know, just hold your ground. Stay strong. And the judge will never have the guts to make you do this. It was a hard decision. There's no doubt it was a hard decision. It was the right decision. Because, Your Honor, if any adult came in and said, I'm not going to follow your orders. I'm not going to stay at home on house arrest. I'm not going to do any of this stuff that you tell me to do. Essentially, screw you. You have no choice, Your Honor, and that doesn't change with children. There is absolutely no prohibition in the general law or the family law that says children who are subject to the orders of the court don't have to follow those orders. There's absolutely nothing in the general law or the family law that say you can't enter orders against children. And there's nothing that says you can't enforce those orders against children. The fact of the matter is, there was nothing left. The mother wasn't getting this done, but the mother was bringing them to parenting time. The mother, when she didn't bring them to parenting time, was held in contempt. When she was doing something wrong, she was held in contempt. By her agreement, she was held in contempt and spent a day or a day and a half at the animal shelter after spending a half a day. But the children, Your Honor, would come with her and refuse to communicate, would put their head down on the table, would lock their arms together and look at the floor, refuse to talk to anybody of authority, and then, if they had to go in, would swing around and say, I'm not talking to you. Your Honor, that's a blatant refusal to follow orders. In the view and presence of the court, they told her, I'm not going to do it. The judge had the full discretion during this civil contempt hearing, this hearing that everybody who testified in this hearing understood to be a civil contempt hearing, to hold them in contempt until they complied with the orders. Her orders are clear. It is a civil contempt. They are complying. Your Honor, I don't know what hearing I missed, because not a single witness here testified about what criminal contempt was. Not a single witness here testified that they thought, standing in the room while it was happening, that the children were being punished. If the children were being punished, Your Honor, then what is the point of giving them the advice to apologize to the court and try to avoid contempt? They're already in front of the court on a criminal contempt for a violation in the past. The only question at that point is, did you do it? In this particular case, Your Honor, they didn't say, the question wasn't, did you do it? The question was, will you do it? And the answer was as clear as crystal. No, we will not do it. Now, Your Honor, will a judge get frustrated sometimes when that happens? Absolutely. Will a judge get exasperated sometimes when that happens? Absolutely. I see judges exasperated every week on Mondays in Macomb, Wednesdays in Oakland, and a lot on Fridays in Wayne. The fact of the matter is, Your Honor, there are times when I frustrate the hell out of you. There's no doubt about it. There are times when I push Judge Warren to admonish me. There's no doubt about it. But when he gets frustrated and exasperated, when you used to get frustrated and exasperated with me, nobody said, let's go to the JTC. For God's sake, a judge is angry. For God's sake, a person in front of me has pushed me to the point where I raised my voice. Judges raise their voices all the time. Judges are sarcastic all the time. Judges, unfortunately, get frustrated and exasperated. They're not robots. Sometimes, Your Honor, judges swear on the record. Judge Gorcyca doesn't. She testified she doesn't swear at all. We've seen 2 hearings here. She didn't swear at all. I think she had every right to, Your Honor, but she didn't. Some judges, and this has happened to me, believe it or not, throw things from the bench. Judge Gorcyca didn't. Your Honor, those are acts that are bordering on misconduct. I didn't walk away from any of those hearings and say, I've got to rush to the JTC. I just took the piece of graphite out of my shoulder and just went on. The fact of the matter is, Your Honor, the judge is a good judge. She has a wonderful demeanor from the bench. She's respected by everybody that she has ever had practice in front of her. There have been 2 letters of support out there, one signed by over 50 attorneys, one signed by 200 attorneys.
Objection, Your Honor.
Who say
that's not part of the record.
Noted.
Who say she's one of the best judges in the state. And she is. She's a wonderful judge who cares about the people in front of her, cares about the families in front of her, and cares to make things better. When Omer Simone, the father, comes to her court and says, Judge, I'm still trying. I haven't given up. Judge, I want parenting time. I want you to bring the kids to me. She has no choice but to do that. He has a right to parenting time. They have a right to parenting time. If Omer Simone had just said, I give up. I'm going to go back to Israel and just forget that I have kids. That would have been the best thing for all, right? Except for Omer Simone and the kids. He wanted a relationship with his kids. He wanted to be there for them. He wanted them to build a relationship with him. He knew he was working in Israel. He knew he only got to see them 3 or 4 times a year for 2 weeks at a time or several days at a time or whatever, but he wanted that time with his kids. And he wanted his kids to work with him. And Judge Gorcyca, trying everything she could to get them to at least try to build a relationship. You know, if they had tried and they had come to the court and said, you know, Judge, I've talked with him long and hard. He doesn't like soccer. I do like soccer. We're just never going to get along. Then the judge might have done something different. But instead what happened is the children would throw their back at him, cross their arms, and say, I will not speak to him. Period. He didn't know what his kids liked. His kids didn't know what he was like. What is the judge supposed to do when he says, I need to know my kids? She tries to control the behavior. The behavior, Your Honor, is what a judge has control over. She can't make them love him. She can't make them respect him. She can't make them even like him. Maybe she can't go in and physically move their mouths. But she can tell them to participate. She can tell them to communicate. She can tell them to get in the darn room already. I'm not going to spend 2 hours every time you show up doing this. She can tell them where to have it, who to have it in front of, when to have it. She can control behavior. And the behavior of the children, as Mr. Lancet told you repeatedly, never changed. Never improved. Your Honor, I'd be frustrated. I might have sworn. I might have thrown my pencil. I deal with frustration a little differently than Judge Gorcyca does. And Judge Gorcyca didn't deal with it badly in this case. Were there things that she said that she wished she hadn't said? She told you there were. She's admitted in her 28-day letter in her answer that there were. She has said, I probably shouldn't have used the Manson reference, although everybody in the room had seen the report from November 3, except for the kids' attorneys. And none of them thought that her demeanor was bad anyways, even with the reference. The attorneys for the parties had that report. Nobody even raised their eyebrows when she said it. Nobody said, "Oh my God, Judge, what the heck are you doing?" Nobody questioned her at all until Mr. Fisher and Ms. Renier questioned her. Nobody, Your Honor, who was in that hearing objected. Nobody asked for superintending control. Nobody appealed. Nobody did anything until Mr. Fisher and Ms. Renier got some bee in their bonnet about it and decided to investigate it on their own. The fact of the matter is, Your Honor, this was a normal court hearing that nobody would have ever known about except for the media, except for plaintiff's attorney number 17, 18, when Lisa Stern went to the media and said, "Look what happened here." The fact of the matter is, Your Honor, it was a valid hearing. It was procedurally sound. The orders were procedurally correct. This was a civil contempt hearing that was appropriately held. There was no evidence, and there is no evidence, that this was a criminal contempt. Now, that being said, if it is, if you decide it's a criminal contempt, if you decide the judge did something wrong, if you decide that she just messed up on civil contempt, okay. There's nothing you can do about that. This tribunal has no jurisdiction over appealable issues. Sometimes, Your Honor, judges get it wrong, and we acknowledge that sometimes judges can get it wrong because we have appeals courts. When you decide a motion and I don't agree with you, I get to go and ask 3 gentlemen over in the old GM building to overturn you. Sometimes they do, sometimes they don't. If she was wrong in some legal sense, an errant ruling by a judge made in good faith is not misconduct. Whether the judge inappropriately applied the rules of civil contempt, thank you, is not an issue for you to decide. The issue for you to decide is whether the judge acted in good faith. And the judge clearly acted in good faith. 5.5 years of therapy, 5.5 years of parenting time, of all sorts of machinations. I think Mr. Lance had said every machination. The witnesses told you they went to the zoo. The witnesses told you they went to the favorite restaurants. They went to the courthouse. They went to the park. They tried with a dog. They tried without a dog. They tried with electronics. They tried without electronics. They were at the library and they would jump on the computers and ignore, so they wouldn't allow them to use the computers there. The judge finally said, with the consent of the parties, with the stipulation of the parties, all right, let's do it here. I'll be able to intervene as necessary. And she saw what was going on at that time. And the assistant prosecutor said, "Judge, throw him in today. And the judge said, no. Mother, go take care of it. If you don't take care of it, I'm going to have the deputies take care of it. And so along the way, applying draconian measures, perhaps, that were suggested by Mr. Lansat, she tries to ground them. The mother wasn't grounding them sufficiently to get them to cooperate, so she grounds them. You can't use your Game Boys. You can't watch your TV. Do they even have Game Boys anymore? You can't watch your TV. You can't visit with your friends.
You'll have to look that up in your word processor.
Not my word processor. There you go. When you go out to dinner with your father, if you don't eat, you don't eat. My mother used to say the same thing to me. I tried to say before. If you don't eat what I give you, yeah, you don't eat. It's as simple as that. Draconian. Things that my mother did, their mother should have done. Wasn't working, wasn't improving the way. She told them, with the consent of the parties, listen, you're not following my orders, go tour Children's Village. That wasn't a field trip. That was a clear message. You guys aren't following my orders. Go look at where I've got to put you if I've got to be pushed that far. And even so, come in here for spring break so again I can watch you. These are draconian measures, Your Honor. The courts have so much more important things to do than this. Except, in Judge Gorcyca's mind, this was important. This was very important. This was a father who needed to have a relationship with his kids that had been thwarted and ignored by the kids for 5.5 years. So she tried draconian measure after draconian measure after draconian measure after draconian measure. Until finally, having it in the jury room again, a very unusual circumstance, they turn to her and say, I know I always listen to my mother. I know my mother has told me to do this. I know you have come in and told me to do this, but I'm not going to do this. And the judge says, I'm fed up. I don't have any tools left. I don't have anything I can do. I'm going to appoint attorneys that I hope are going to talk some sense into you. And she does so. 3 well-respected, experienced attorneys to talk some sense into them. One of them, Michael Dean, even got RT to come in and say, Dad, I will communicate with you. But as soon as Judge Gorcyca said to him, your older brother went to jail, he did a 180. And he says, I will go with my brother. To which the judge responds, where? And he says, Children's Village. Now, there's an allegation in this case that Judge Gorcyca over-described Mandy's place. If she was describing Mandy's place, yes, she probably over-described Mandy's place. But she never says on the record that Mandy's place has cells. And she never says on the record that Mandy's place has bathroom facilities with no privacy. And she never says on the record that Mandy's place has uncomfortable beds. She says Children's Village does. Now, why is she talking about Children's Village? I think, Your Honor, because she's trying to deter these children from their contemptuous behavior. I think she's trying to impress upon them at this time that you need to follow these orders because you don't want to be over there, something Karen Cook described on the record as jail. Your Honor, that was necessary. Because as you heard Brittany Kelso describe Mandy's place today on the July 10 hearing, and if Judge Gorcyca had said, follow my orders, or I'm going to send you across the parking lot, you're going to have field trips, play basketball whenever you want, have 3 squares, and hang around with kids your own age. I'm betting that wouldn't have made them follow the orders either. I'm betting it would have been exactly the same result. Your Honor, she was trying to instill a parental relationship. She was continuing to try to instill a parental relationship. To claim that she over-described Mandy's place is almost a ridiculous claim. She didn't say the kids would be chained to a wall in the sub-dungeon. She didn't say that the kids would be on a Mississippi chain gang. She didn't talk about things that didn't exist at Children's Village. She was talking about Children's Village in an effort to deter the kids' contemptuous behavior. Ultimately, it didn't. We know that. And so the children were sent to Mandy's place, which is an appropriate placement, and they were there, and on July 10 there was a review hearing where their attorneys both said, kids haven't changed their mind. Whether Dad had the keys to it, whether the kids had the keys to it, I think everybody had the keys to it. The kids hadn't changed their mind. They came in on July 10 and they said, their position is, I want to go home with Mom and I'm not going to see my dad. They were still in contempt of her orders at that time, Your Honor. This idea, this red herring that the judge must have known, could have known, should have known that the father was going to be in Israel is a silly contention when the kids came in on July 10 and said, I'm still not going to talk to my dad. Your Honor, the point of the matter is, the GAL, acting in the best interest of the children, said, Judge, your contempt hearing, your contempt order is not doing what we wanted it to do. I'm telling you as the GAL, I think it's in the best interest of these children to be removed from Mandy's place and sent to Camp Tamarack. The judge, respecting every report and recommendation that GAL had provided to her, realized even my contempt tool is nothing compared to the defiance and contempt of these children. And so, I'm holding them unnecessarily at this point. I'm going to lift the contempt order. They can go to Camp Tamarack on the motion of the father and the GAL, but I realize it's not working anymore. There's no rule under the contempt, Your Honor, to bring the person back in an hour. There's no rule to bring the person back in a day. There's no rule to bring the people back in a week and say, are you still in contempt? It's up to them. And we know that by July 10, they still didn't want to follow the court's orders. So these red herrings mean nothing. Now, that deals with the contempt issue. Count 2 of the complaint is a misrepresentation count, Your Honor. The first one of those is that the judge misrepresented that she sent the kids to Mandy's place because they wouldn't have lunch with their father. Lunch with their father on that particular day was a last-ditch effort to get the kids to participate in parenting time. She said, listen, go down to the cafeteria and have lunch with your father and everything will be fine. But you told me this before. Your mother has told me this before. I'm going to keep an eye on this. I'm going to make sure that you're participating in parenting time. And if you're not, you're going to come back here at 1:30. But go and have lunch with your father. And what did they say? No. I would rather be at Children's Village. I refuse because I want to refuse. And this order had nothing to do with lunch. This order had to do with parenting time. Prospective parenting time. When the children said, I won't do it, the judge had no choice but to hold them in contempt. That's not a misrepresentation when the judge says, yes, I held them in contempt because they refused to talk to their father. But I didn't hold them in contempt because they refused to have lunch with their father. It was a partial denial. The second misrepresentation, claim, allegation, is about this finger gesture There are universal gestures, Your Honor. They're thrown at me quite often. I've seen a lot of them. I don't see a lot of people do what Judge Gorcyca did with a pen in her hand. Not many people call me crazy. They call me a lot of other things. But Judge Gorcyca acknowledged what it looked like in her 28-day letter and in her answer to the formal complaint. She said, listen, I see it. I don't remember doing it. I don't remember pointing at Ms. Rainier. I don't remember waving my hands when I was talking about something else. I don't know I'm talking with my hands. But I see what it looks like. And I can see how somebody might take it. And to the extent somebody understands it that way, I apologize. But I know, in my heart of hearts, having no real memory of doing this, because I don't have any real memory of any of my gestures, I know in my heart of hearts that I don't use the N-word, that I don't say G-O-D, that I don't insult people. And so I can't believe, in my heart of hearts, that I meant to insult or offend anybody in that courtroom. That's her belief, Your Honor. A belief is not the basis of a misrepresentation claim. She said, now, I still don't know what I meant, but the court rules require me to cooperate with the JTC, to provide a fair and full accounting of my actions. And so, Chris, she says, I think I got to come up with what I believe. I said, well, Judge, what do you believe? And she says, I believe, because I was talking about therapy at that time, that it meant he would be moving forward in therapy. Now, Your Honor, she is talking about therapy at that time. Father, if you believe that LT is moving forward with therapy and is no longer like Charlie Manson's cult, she never said Charlie Manson. Nobody compared anybody to a serial killer. It's always a communication issue. You'll let me know. That gesture came equidistantly between therapy and Manson. You can look in one direction or you can look in the other. But what you can't do is say that what Judge Gorcyca believes was a misrepresentation, because there was no witness there who said she believed otherwise. There was no incriminating witness over here that said, you know, I talked to Judge Gorcyca and she told me she was lying all right from the start, because there's nothing there like that. She doesn't use the N-word, she doesn't use G-O-D, and she doesn't call people crazy with this. She just doesn't. And I've given her a lot of opportunity in the time that I've spent with her to use the bird too, and she hasn't thrown that at me. So, you know, the fact of the matter is, Your Honor, there's no proof here that there was a misrepresentation. One of the claims is based on the false predicate that this was a criminal contempt hearing, which it was not. It was a perfect, procedurally sound civil contempt hearing. And even if it wasn't, Court of Appeals will deal with that. The misrepresentation claims, or the second one, Your Honor, is based upon Judge Gore. Her statement was based upon her belief. If Ms. Rainier and Mr. Fisher don't believe her, well, I wasn't able to call them as witnesses to cross-examine that. They're not the arbiters of what Judge Gorcyca believes. They're the arbiters of what they believe. But judicial misconduct is not defined as whatever Mr. Fisher believes or whatever Ms. Rainier argues. Judicial misconduct, Your Honor, is not in this case. Now, Mr. Cranmer, from the very beginning of this case, in his opening, told you that this is an important case to Judge Gorcyca. There's no doubt that this is an important case to Judge Gorcyca. I think, Your Honor, A lot of the judges across the state have stopped whatever they were doing to watch these proceedings because this is an important case across the state. This is a case where a judge who had tried everything before had to make a hard decision. This is a case where a judge, even with children in front of her, had to deal with their failing to follow the orders. This is a judge who did care, and did care too much, maybe, for this family, and continues to care about this family. If she's found to be in misconduct because she raised her voice or was sarcastic in light of such an exasperating and frustrating situation, then, Your Honor, no judge is going to listen to the father's plaintive cries. No judge is going to tell the mother, you have to bring your kids. No judge is going to tell the kids, you have to communicate. It's an unusual case. It's number one on the unusual scale of her 46,000 cases. Hopefully these other judges won't be put in this position. But if she's found to have committed misconduct because of this hearing, then what you are doing is telling other judges, don't do it. Because if you do, you might tick off Mr. Fisher, or you might tick off Ms. Renier, and they'll follow you until the conclusion of the hearing. Your Honor, there's no misconduct here. I think that this case is simply an overblown opinion that has gone way too far. Thanks.
Rebuttal?
So somehow this court is supposed to worry about what other judges will take from this case, because somehow Mr. Fisher and myself have decided to proceed with this case. Counsel knows very well, it is the commission who authorizes the complaint. Not Mr. Fisher, not me. Do other judges follow this? I hope so. Because the message to everyone who takes the bench in this state should be, follow the law. Accord everyone due process. Hold hearings when those are mandated by the law. And I will just address a few points. The fact that Judge Gorcyca called it a civil contempt, or the three children's attorneys called it civil contempt, doesn't make any difference in your determination as to what this is. As far as three experienced attorneys appointed for these kids, Mr. Lancet was on this witness stand for over an hour trying to explain things. Each attorney had about 15 minutes with each child. And Mr. Schwartz said on July 10th, 17 days after his client got locked up, that he had to explain to his client his role as an advocate for him. Counsel's talking about LT's refusal. Let's not forget something. LT was not part of the June 23rd, 2015 order. But counsel is pointing to, I will not talk to him, coming from this 13-year-old child, so the judge could have held him in contempt of court. I will point to this court to in re contempt of Doherty, 429 Michigan 81. Future intent to violate a court order is not subject to a court's contempt power. Another comment counsel made, well, if an adult said, I will not obey an order, what's the court to do? Set it for a criminal contempt. File a petition, file an affidavit. Do it by the rules. And this is not a case of good faith. This is not a case of an appeal. You can't say, I will not follow the law. I will violate every law. I will violate the kids' due process, but if you're not happy about that, go ahead and appeal. And, Your Honor, perhaps the saddest comment that counsel had made is that no one stood up for those kids. No one objected. No one said, wait. This is a criminal contempt. No one said, let me look into it, let me research this. Even more sad is the comment that no one would have known anything if it wasn't reported by Ms. Stern to the media. Thank God she did, so that these incidents can be looked into. Court is open to the public. It should be. It has to be. It is for the benefit of the litigant. The fact that Ms. Stern reported it to the media is certainly nothing improper. Thank you.
Thank you. All right, pursuant to Rule 9.214, counsel, within 21 days after receipt of the transcript of the proceedings that are provided the master, should prepare and transmit to the commission a duplicate of the report that contains a brief statement of the proceedings, findings of fact, and conclusions of law with respect to the issues presented in the complaint, the answer, and in these proceedings, including the two directed verdict motions that you've made on behalf of the respondent. At this point in time, with all of the testimony and the evidence that has been submitted, the hearing is concluded. Thank you.
Thank you, Your Honor.